topic. And this source of inspiration came from working together on a case. We worked together, and actually together with another colleague that is here, and I'm going to welcome and with, of course, Andrew's colleague here, for a case. I'm not able at this moment to disclose the details, but I'm going to disclose something. That it was a truly helpful cooperation that helps us to dig into piles of documents with tons of data and with some very complicated way of identifying the most relevant issues. And finally, by this joint effort of the expert to identify the relevant data and present that data in a manner that was really appropriate for an arbitrator to understand, and with the work of the counsel who put those data into the legal context, so to build the legal argument that was supported by the facts as demonstrated by the expert, we have managed to succeed to something that was really amazing. The opponent counsel in that case, after receiving our pleading and the expert report, chose to waive about 2/3 of his claim, change its expert, and reshape its pleading, hire a new expert for the last remaining third of his case that he still maintained in dispute. Now that is something that our work together did, and I'm very proud for that. It's not about how much money are in dispute always. Of course, it's important to talk about money, but it's about the principle. The principle is that when you see a good work, then you admit that that good work is very difficult to be challenging for. And I would have a very good word to say about both the team that we were at that time to work and prepare the case in such manner as it was obviously leading to the conclusion that 2/3 of the claim was not unsubstantiated. But I would also pay true respect for the second expert that the other party has chosen to hire, who understood, accepted, and was independent enough to advise its client that it is no longer possible to maintain the 2/3. It's only possible to try to do something with the 1/3 possibly, and that is why he continues. But he chose to accept this idea, and that was also to be respected, professionally speaking, from the part of an expert. So all technical experts in this case were to be of true independence and also of true help to their clients. Now, why I asked Andrew to be present here is not only because of this experience that we have encountered together, but also about his impressive CV. He will tell you something more about himself, but what I can notice from CV that I have also distributed to you is that he has actually given evidence in front of not only tribunal, like in regular protocol, like the High Court or the Crown Court in the UK, but also international arbitrations, like arbitrations under ICC rules in Paris, or UNCITRAL, or ICSID in front of the arbitral tribunal by the World Bank. I'm speaking of those students that are less informed at this moment about this type of arbitration. His work over the last 20 years included a wide range of issues like audit, corporate finance, due diligence, internal audit, and corporate recovery liquidity trials. And prior to joining ALIX Partners, he was a director of the forensic department of KPMG and led their engineering and construction team. He was also previously in the dispute analysis and investigation team with PricewaterhouseCoopers in London. So I can see that I have gathered here important colleagues at some moment in time. You have noticed something that our previous speaker, Mrs. Bobacha, had training prior to her work in the auditing as engineer. Andrew, on the other hand, has a degree in mathematics. So as opposed to many of us lawyers who are just jumping into the profession of pursuing other papers that they are right, which is a very nice job and a very rewarding one and a very necessary one in society, experts do tend to go to some basic necessarily trained to be experts. They are trained to be professionals in a certain area, which may be mathematics, which may be engineering, which may be accountancy, which may be, I don't know, various other areas, chemistry, biology, whatever. So they are not trained in the profession of pursuing others, to do something or convincing others about their own views. They are not trained in advocacy. Their training is in analysis, and their training is in some sort of science education, and not. It doesn't mean that they are not able to perform this role of counseling, but they are not trained to do so. This training somehow appears in time, and it goes through practice. And what I can tell you is that it is, to paraphrase a little bit the title for any Grantham presentation, it is the added value of their own intrinsic value as professionals that finally leads them to be able to pursue others. So it's a lot of inherent competence, inherent professional value that is behind any kind of persuasive argument or advocacy that they want to do. Now, that being said, with the great respect for the work of Andrew so far, and with great hope for us to be able to meet in the future in other professional context, I will give him the floor.
Thank you very much. Good afternoon. First off, I agree with everything that Cornelia said. I thought it was a very good summary. While she was speaking, I've noted down a few questions which we can add on to and hopefully if we've got time. I've also got a confession to make. The reason I say that is because I think one of the questions we can discuss at the end is how experts could work together on the same side. Because my confession is, or a sin, I used to work with Jeff at KPMG doing engineering construction disputes, and so I encountered myself working with an engineer, Jeff, on the same side, but looking at different aspects, and I think that would be quite useful to explore and give you our insights on that. In terms of this talk, I'm going to cover, albeit in 20 minutes, a very specific topic, which is discounting cash flow calculations, used in doing valuations. Just a few simple points to make on that, because I've only got 20 minutes, and I'm sure Cornelia may have some views on it herself, which would be interesting to hear. And then lastly, I've got my own thoughts on points for working with experts and points maybe to take in the future to how it would work better for you. Experts generally, if you want to duck into my report, having two experts, one on either side, I always think is a good thing. If you've got an expert on the other side who's impartial, objective, and an expert on your side who's impartial, objective, having their own views on whatever the topic might be. It might be a medical issue, it might be handwriting, it might be a construction issue, but having the two experts debating it or being cross-examined, I think is a very healthy way for a judge or a tribunal to get to an answer. So I leave that with you in terms of an expert's view as to this very adversarial approach. It might be because I come from a common law jurisdiction, but I like it as a way of getting evidence that can be decided upon. And sometimes it may go for you, sometimes it may go against you, but I think it's a very good way. In terms of my experience, I've been doing expert witness work for 25 years. Some of it's loss of profits calculations, a lot of it in arbitration is valuation of a corporate entity. And that's really the content of it. In terms of giving expert evidence, it's ranged from 5 seconds to 6 days. So it's quite a broad reach. The 5 seconds was in an arbitration. It was a shareholders dispute. There was only one question from the other side, and this was a joint venture dispute regarding a Greek shipping company or management company. And the question was, Mr. Grantham, do you think the prevalence of fraud is greater in Greece than in other countries? To which I said, yes, I believe it is. That would be the common perception of the Greek economy. Expecting a whole flurry of questions to follow up that, what I thought might be a controversial answer. And that was it. He said no further questions. So 5 seconds, and that's what essentially. That can range, and this, the reason I mention this is because of your question, to 6 days. That was in a criminal case in the UK. My legal counsel on that case did not want to speak to me at all. In fact, she only said one thing to me before I went into the witness box, and this bit of work had taken 2 years to produce the report. And she said, I do want to speak to you about that report. And the first time I will speak to you about it is when you're in the witness box and I'm going to be examining you in chief. She only said one thing to me as I was walking into the witness box was that the other barrister on the side is trying to call the jury. I think you'll be in there for 3 days. As it turned out, I was in there for 6, so he really did try and call the jury, or I was very slow with my answers. So in terms of answering your question, the lawyers may have a different approach to that question, depending on how they see the implications by the jury, the judge, or the tribunal as to how they've been involved with their experts. It might be that they prefer to have nothing more to do with the experts prior to seeing them in the tribunal court. That might be sort of at one end of the spectrum. I'm sure that the discussion we'll have later will be somewhere sort of in the middle as to what's appropriate and what's not appropriate. In terms of valuations in cases, this is a selection. It doesn't include ours. It's a selection of valuations that I've done over the last couple of years. They're in different industries. The reasons for doing evaluation can be varied. That will depend on the nature of the legal dispute. It can range from, you mentioned, sell and purchase agreement disputes. It's a breach of warranty dispute, so the buyer is arguing that they paid too much for the company because if they had known of certain facts when they bought the company, they would have paid less for the company. So you're asked to do a valuation of that company on the basis that those facts would become known. And the question is, would it affect the valuation, which is a key point to consider. You're looking at other shareholder types of disputes might give rise to a valuation. The telecommunications case that you see there, that was one party believing that the preemption rights in the shareholder agreement had been adhered to. They therefore hadn't been allowed to buy shares in the company, and they were arguing that they should have been allowed to buy the shares in that company, and if they had done it 5 years ago and the value of the shares had grown, that's the loss that they have suffered. And then it comes to expropriation cases. So the example of ours was an expropriation case. There you were trying to value the company or a business at a particular point in time, allegedly because it had been expropriated. So you're having to value that company. So there can be different contexts to which you're doing valuation, but the basis, in general terms, in which you're doing valuation stays the same in terms of the methodology. There are different methodologies that you can use to value a company. Some are more appropriate than others, depending on the circumstances or depending on the company or the industry that you're looking at. I've got up there 4. Those are the most commonly known. Discounted cash flow, which I'll talk about in more detail. Sales evidence method, i.e. has this company been sold before, and what was it sold at? Included in there might also be other companies that have been sold in that particular industry at roughly the same time that you could use as a benchmark. Attainable earnings, there you're looking at listed company information as to multiples that you can apply in terms of valuation. And then lastly, assets-based. These are generally used for property companies because you're basically the company owns properties or a restaurant, say. Or it might be that this is an appropriate method to use because a company's in financial distress. If it's in financial distress, you might be arguing that it doesn't have a going concern and therefore you can value it on an asset basis or a rate basis. The circumstances of the case and the nature of the company that's involved will determine which methods are available or that you should be using rather. Importantly, I would always advocate, I do advocate sometimes, that you would use different methodologies as a cross-check. There's probably one methodology which is preferable to others, but it would be useful to compare the results of one methodology against another. It's useful. So, DCF. It receives quite a lot of airtime because of exit cases and as to what tribunals view in terms of whether the methodology is appropriate or not. In exit cases, maybe a bit of a generalisation, but those times when it's been criticised are the companies which have been in a start-up position. So if a company doesn't have a track record by which you can, the tribunal or value can measure how that company is doing and then assume what it might do in the future. Where companies don't have that track record because it's a start-up, I think tribunals have been reluctant to adopt that methodology. All damages cases involve some degree of speculation. But speculation is something that the lawyers like talking about and like throwing doubt into the situation because of the degree of speculation. So I spent a wonderful half day last year, albeit it was only half day of cross-examination in Paris, in an ICT arbitration, being asked questions about how speculative my damages methodology was by the lawyer on the side. There is always going to be some degree of speculation in this, and we'll come on to how you might deal with that in a little while. But the DCF methodology, it's a methodology which has to make assumptions as to how a company is going to do in the future. And those assumptions involve some degree of, you have to make assumptions of what you're going to forecast, and that has some uncertainty attached to it. There are ways in which you can deal with that uncertainty in a DCF. You can either reduce the cash flows, discounted cash flow, or you can adjust the discount rate. You've got the ability to do both. And I won't go into it now, but there are general principles about which bit you should adjust as being the preferred treatment by the professional when you use this methodology. It might be that the experts disagree on whether you should use a DCF at all. That normally is in a startup situation. And I'll come on to an example of a case where I acted as expert in a startup situation to try and explain that. So that's one area of disputes between the experts, the methodology you use. The second area is the assumptions. So you might find myself and Cornelia debating over the assumptions that should be used. What's the level of growth that this company should expect? What are the margins in the business? What are the overheads? What are the incremental costs? How much capital you need to put into the business to enable it to grow? It's a complicated exercise, and you do need to go through it carefully. But it does lead to debates, honest debates, good, healthy debates between the experts. So, an example just to illustrate some of these points. This was a valuation of a retail company. I won't tell you the context, I won't tell you where, but it was a retail company. The claimant's expert alleged that this company was worth $300 million, and in doing so used the DCF method. He assumed a discount rate of 25%, and he assumed a growth rate in perpetuity about 5%. So, in terms of looking at the graph, in perpetuity, it's assuming that in 2017, this company would continue to grow in terms of its revenues by 5% each year. We may have a debate about that later on, but I'll give my views and then you can give me a debate about it. This graph sets out the present values of those cash flows on a yearly basis. The first issue I had with this was that this was a startup, and in fact, it was actually before a startup. It was an idea that a businessman had at the point in time that the tribunal wanted the valuation. It was an idea that the businessman had for a company. So this company, this retail company, didn't have any shops, didn't have any financing, didn't have a shareholders agreement, it had nothing. I think he was sat at home thinking, do I set up this company? Anyway, the legal position was you've got to value this company at that point in time. Because of this individual, I said it might be that that idea had some value. I was hesitant, reluctant even to put value on that. So I said in my report, there's probably minimal value there. Because of this individual, he might be able to sell it to another businessman, provided he got involved in the business. But I didn't believe that a DCF was relevant or appropriate in these circumstances. It's difficult buying a startup, and why use a very complicated DCF to value an idea when you could produce any figure? And that was the point that I got across to the tribunal, because I did some sensitivity analysis on the DCF model. Notwithstanding I disagree with its use, I did some sensitivity analysis. So, what did we do? We had a meeting of experts, and I convinced the expert that his discount rate was too low. He increased it to 30%. He had used 25%, he increased it to 30%. He set this out in the joint experts report. I still disagree with the 30% mind you, but he put in 30%. That reduced the value of this company by 150 million to 150 million. Counsel for respondent where I can put it to him quite rightly, well, just by making one small adjustment, 150 million has disappeared. How can it just disappear? And he did struggle with that in terms of cross-examination to justify how his value of this company, by just adjusting one small thing, had caused his valuation to come down by 150 million. We had other small adjustments that we put in front of the tribunal, one of which was to lower the terminal growth rate to 2% as opposed to 5%. That also made a significant difference. And I won't go through all of the small adjustments that we made, but as a result of all those small adjustments, we got down from 300 million to a figure of 5 million. Quite a substantial decrease. As it turned out, the tribunal found in favour of our client on some legal arguments, so the damages part never, they didn't even have to consider that, because the legal argument had gone away. But they did comment on the damages calculation, and they did agree with the fact that valuing an idea was difficult, but they couldn't see that you could attribute much value, if anything, to an idea. So it was a good result all round for our client. Lastly, let me touch on points working with an expert, which sort of followed on from the previous talk. Experts are required in many disciplines to give expert evidence in litigation and arbitration. From a damages expert, the work that we do, from my perspective, doesn't really differ. I don't know whether you agree or disagree with that. It doesn't really differ. You produce a report. You might have a meeting of experts, you might not. I'll touch on that in a second. You'll see a report from the other side's expert, you produce a reply report, and then you give expert evidence in front of the tribunal or a judge. There's no real difference really in that. Where there are differences in arbitration is the manner in which you might give oral evidence, and you touched or gave you cross-examined, you might give presentations, you might go into hot tubbing, you might do all three. I'll leave my personal preferences and views until maybe the Q&A session. The one thing I would say at this point though is in terms of meetings of experts, I know Jeff probably in the construction field has a lot more meetings of experts before the experts have written their report, and be interested as to how his views on how good that works or not. Certainly in the work that I do, the meetings of experts always come after you produce your report. People are reluctant to change their views when they've gone into print already. There is a difficulty there. But I'm surprised that there aren't more meetings of experts in arbitrations. I am surprised. When there are meetings of experts, at the end of it you produce a joint statement, an agreed joint statement, which summarises the areas of agreement and the disagreement. And I think, certainly from speaking to legal counsel and judges in the UK, first thing they generally turn to is the joint report to see which areas are agreed so they can understand it, but put that to one side. But more importantly, understand the areas of disagreement, because those are the points that they're going to focus on. And it might be those areas of disagreement which form the issues for the hot topic, which can come later on. Lastly, in terms of working with your expert, I would also support work with your expert early. From a cost standpoint, generally speaking, it's probably cheaper to get your expert involved early. Do not be afraid that by getting them involved early and giving them all the pleas to read through, that the costs are going to spiral out of control and then you have to difficulty explaining that to your client. Over the course of the arbitration litigation, you will save costs if you get your expert involved early. There are also the value-added points about the benefits to the client of getting your experts and your lawyers working together at an early stage, which is already referred to. I hope you support that. So I would support getting the experts involved early. It's very difficult sometimes when lawyers only feed you bits of information. And the reason I say it costs more is because you spend a certain amount of time working through that information, raising all these questions, and then you go, well, I don't know how this works. And you go to the lawyer and say, well, I've got this question, can you help? And yes, we've got this bit of information, let me give that to you. And you spend hours deliberating over whether that information exists, but importantly, what it might show or what it might show, which doesn't make sense to me. So, I would certainly support getting the information to the expert as early as possible. I'm sure I've taken up my allotted time. I'm conscious that Jeff is going fast, so I don't want to really. Thank you very much.